Essential law firm technology policies and plans. Main points are technology users run amok, electronic communication and internet use policy, social media policy, document retention policy, secure password policy, incident response plan, disaster recovery plan, mobile security policies, equipment disposal policy, and litigation hold plan. Technology users run amok. Law offices are using more control over their employees and the use of social media sites. Plans are needed in order to protect the firms against suits and possible legal breaches. Electronic communication and internet use policy. Many firms have established a policy for their employees which sets a limit on their internet use, if any, and have blockers for those sites that are not work-related. Some offices have forbidden video streamlining and have installed additional spyware to aid in the catching of these viruses. Social media policy. Most offices have internal policies on the use of social media on company-owned computers. There's not much said on using their individual devices for surfing the net and or posting to social media. Granted, there is a time for it, and on company time should not be one of them. Document retention policy. The retention period of a document is an aspect of records management and represents the time a document should be kept or retained, both electronically and in paper format. Document is usually destroyed at the end of the retention period. Secure password policy. Only the largest law firms tend to have a secure password policy. Passwords need to be changed every 30 days and cannot be repeated and not reused elsewhere, as in logins and screensavers should also be different. Fact 1. The secure password is an easy one to compose due to the 8-digit password can easily be cracked in less than 2 hours. Fact 2. This is also proven that it takes approximately 17,000 years to crack a strong 12-character password. Incident response plan. This plan generally refers to some sort of security compromise, most often a data breach, although it can also cover attempted breaches, security alarms, unauthorized access by employees. The breaches are occurring in law firms in 46 states. In addition, the District of Columbia have data breach notification laws, with a possible federal law looming on the horizon. Businesses that offer these services have been in high demand, especially where IT is concerned, whether offering satellite or mobile offices for one or many businesses. Mobile security policies. Lawyers' mobility has expanded so much in the last 10 years that most of us can now work from anywhere and have access to our office documents as long as we have an internet connection. But all this connectivity means we have serious security concerns as we connect laptops, tablets, and smartphones. It is critical that our remote connections are secure and that we transport and store confidential data in a secure manner. Equipment disposal policy. Based on current priorities, this policy emphasizes the need to control data and on IT equipment during use, internal transfer, and disposal. It is important for an asset disposal policy to be tied to an IT asset usage policy because many of the issues faced in disposal should be considered and communicated to employees when given the tools, assets to use. Litigation hold plan. The duty to preserve relevant information begins with when one can reasonably anticipate litigation. To meet this obligation, an effective defensible legal hold process is necessary, to minimize the risk of spoliation, sanctions, and the damage to the organization's reputation. From the reasonable anticipation of litigation to custodian and data identification through preservation and collection. Attached are the references